Welcome back, and thank you for coming to the second keynote speech of the day, everybody. I hope you're having a good day. My name is Conor McCormick. I'm the Deputy Editor of the European Human Rights Law Review. And through that role, I've had the good fortune of coming into contact with Conor Senior over here over the past year or two in particular. There's a lot I could say about Conor Gearty's many accomplishments, but I'm going to have to restrict myself to the first few lines of his biography, followed by a word or two about his support for the journal. So he was born in Ireland. Conor studied law at University College Dublin and then qualified as a solicitor. He then came to this place in 1980 to study for a master's degree and stayed on to complete his PhD at Cambridge on environmental law. In 1983, he became a fellow of Emmanuel College and obtained a lectureship at Cambridge. This was all before Conor Jr. was born. Okay, I'll try. So in 1990, Conor moved to the School of Law at King's College London, where he developed human rights law into one of the most popular subjects on the undergraduate course long before it was a well-established subject. He moved to the LSE in 2002, where he has stayed ever since. Throughout a very large portion of Conor's distinguished career, I happen to know that he has been a truly dedicated supporter of the European Human Rights Law Review. I had a look through the archives and I counted no fewer than 17 reviews or articles in our journal alone, which says a lot about the level of support he has provided, which says nothing at the same time about the amount of support he's given by way of the editorial board. So I think it's really genuinely fitting that Conor has agreed to give a keynote at this inaugural conference organised by our superb general editors. Conor, thank you for everything you've done for the journal, and thank you for agreeing to speak today. Over to you.
Thank you very much. You won't be surprised to know that I deplored the arrival of Conor Jr. on the academic scene, because for years my unique selling point was that everybody could remember me, and all they had to know was there was only one N in Conor. And now, a Conor I could deal with. Conor arrived a bit earlier, and now we have the child here, who was not even a fetus when I was in my 15th year of academic life. So I'm delighted to do this. Let me just say a couple of things. One is, it's amazing what the new editors have done with this journal. It's amazing to have a conference of this depth and range is an incredible tribute to hard work. It's amazing how underestimated hard work is in any of our work environments, and behind the effortlessness of this has been obviously tremendous labor. So I want to pay tribute to them. It's incredible. The second thing I wanted to say is those 17 articles or opinions or book reviews. Jonathan Cooper, in whose honor we are meeting and whose memory we salute, a very old friend of mine from many, many years ago, sadly died suddenly and tragically, but in a beautiful environment, walking in Scotland, but died to everybody's shock. Jonathan Cooper would ring me up. He edited 6 issues of this journal every year by himself. And he was a barrister, and he was reasonably busy with life, which he also enjoyed. And he would ring me up and he would say, we have no opinion piece and we're due to go to press tomorrow. He knew he was ringing the right person, because opinion pieces you could blather away and they were only about 3. Stop laughing, Robert Craig. We have to keep an eye on the man to my extreme right in every way. And I would do it. So it's not that they were fully refereed. It's not that they were sent out. They were pushed back by return. Anyway, I must get serious. Somebody, a lovely person who met me at lunch, who's now at the University of Newcastle, where are you? Hiding somewhere, I think, and said, you taught me public law. I can't remember any of it except the jokes. Please do jokes. So I didn't know whether that was an insult or a tribute. I wasn't sure. So there's a little bit of seriousness in this. In fact, there's a fair bit. I was going to call it the Council of Europe and Imperialism, an agenda for research when I got down to finalizing it, because it was all very well 2 months ago to say a report card suggesting I would spend weeks visiting Strasbourg, interviewing various people, going into what I believe are called archives and producing some learned discourse. That will come, highly challenging, aggressive editors. That will come when this emerges, if it ever gets in to the European Human Rights Law, which after this conference will be appearing about 10 a year, I imagine. So rich will be its content. And I've already heard some superb papers. But it stayed a report card, despite my wobble on whether I had anything to say. And I have something to say a little bit, which is not only to plug my book, not only to plug my book. And there it is, not yet out, Polity Press, being delivered next week. And these ideas came out of my work for that book. It's called Homeland Insecurity, as you can see. And I submitted myself to torture. We had an Article 3 talk on torture this morning, and she said maybe it was being overinflated, and I've just inflated it further. But tortured by LSE academics yesterday afternoon, going over the script, saying how besides the point it was and so on. But they weren't, but they're temperamentally inclined that way. And what I realized actually was how important, this is really corny, because everybody's now talking about it, but how important the colonial record is to understanding where we are today, and the we there is liberal democracy. And I suppose I'd intuited it, but when I began looking into this subject, one of my fields is terrorism law, was that they don't pay any attention in terrorism studies, of which there is a huge amount of literature separate from terrorism law. They don't pay any attention to the context in which a colonial insurgency took place. So the classic treatments of terrorism don't mention, to take an example, Amritsar, but they do mention the assassination of a sort of functionary. They don't mention coercion, but they mention the terrorist atrocities in response to coercion. So the book is looking for the origins of our anti-terrorism law and trying to explain something which I ask as a question, trying to explain why the war on terror, in inverted commas, was so easy. Now, in our world, our little bubble, we probably think it was fiercely resisted, but it was broadly easy. And my short answer is that we're used to the kind of thing we did in the post-11 September 2001 period through our blinding ourselves to what we, the global North imperial countries, were doing in the subjugated colonial entities. And then I have a chapter on the Cold War. And then I've got a little summary, which I won't go further on, because I want to finish this with enough time for questions. But one of the points that I got to was that one of the ways in which we protected ourselves from the implications of our aggression abroad was by cloaking our aggression abroad in legitimizing language. And there's various legitimizing languages, one of which, emerging reasonably early on, was a commitment to the rule of law. There are lots of others. We're not talking about them here. Commitment to the rule of law. So the stuff that we, the colonial powers, did stopped being just shooting everybody under martial law or active state and became the deployment of legislation. And there's a move after the First World War. There were always previous laws, but there was a move to the legalization of colonial control. And so there's a committee in India called the Rala Committee, and which talks about terrorism being a problem that has to be met by colonial legislation, which they didn't call anti-terrorism law, but which was increasingly being understood as that. And you had the restoration of Order in Ireland Act 1920, which was to do with legalizing counterinsurgency. And again, the language of terrorism came up. So the legalizing allowed us to say that what the violence we did was different. It was organized, regularized, controlled, accountable. And so it was a step up from the anarchy of the subversive. And a part of that was our approach to international law. So quite early on, this is how my book starts, by the way, and it's a very, I think it's fascinating. Compare and contrast Castiglione, 1891, chap in Switzerland, assassinates somebody with a gun, runs off to England, the Swiss want him back. The British say Extradition Act 1870, Section 3, it was a political act. He didn't just kill anybody. He shot at members of the assembly, and there's lots of fascinating quotes about how you can't blame a chap for getting overexcited, and he is able to avail of the political exception. Flash forward 1909, this guy is being sent back to India to face a trial for sedition, having applauded the assassination of functionaries in the Indian colonial office, and he jumps off the boat in Marseille and runs away. And the French get him, or the British get him, go and get him and stick him back in the boat. So it became a point of arbitration between Great Britain and France. And it's available on the web. And basically, it's found not to involve any breach of international rules and obligations. You see the point there. There's no obligation on the power which has in its custody a prisoner to restore him because of a mistake committed by a foreign agent. Anyway, the book's about those double standards, how the rule of law applies in the home, but not in the home away of the colonies. And it applies to the true away, but not to the colonial home away. And law becomes an important justification for this, underpinning an inherent double standards, which allowed, moving into the world of human rights now, which allowed us to describe ourselves as part of a liberal political entity, while not being that in the arenas in the world in which we controlled with a view to the exploitation of their resources and their labor. How does human rights fit with this? Well, this is where we get to the Council of Europe. Obviously, what happens after 1945 is a reconstruction of the way we view the world, and high up there, this is driven, of course, by the United States. High up there is the rule of law. High up there is the UN. High up there is the Universal Declaration of Human Rights. And there's such good recent literature on this, to which I generously acknowledge, on which I generally I acknowledge my reliance. You've got Mark Goodell's book, Reinventing Human Rights, really, really interesting book. And we've got, when you look at it this way, a problem. The problem we've got is that we are saying all these things about human rights, and the people who are saying them, the we who are driving it, are continuing to dominate huge amounts of the world in a subjugated way. So how can we possibly do that while controlling so much of the world? And in those days, in the immediate post-war days, it's not just the United Kingdom, though I concentrate on the British Empire. It's the Dutch hoping to keep bits of Asia. It's the French. You know, the colonial powers were reframing the world in international law terms and in human rights terms while preserving this. Now, they pulled it off to some extent with the League of Nations by adopting this little sleight of hand called trusteeship to be able to continue to dominate. But it was getting harder and harder to pull off. So there were lively debates, Mark has them, about the extent to which we should try and undermine the declaration, too challenging to what we wanted to do. And I say the maligned AA critique revisited. We all have a good laugh about the American Anthropological Association's critique of human rights. Reread it, it's quite interesting. It's making all the points about how this will mask continued domination of colonized peoples and how we need to acknowledge that the interests identified in this are the interests of the North and so on. It's quite interesting for a document that is much maligned. And the Council of Europe, again, the great Brian Simpson's book, which is a compendious, extraordinary analysis, thousands of pages. I likened it to a Wagnerian opera when I reviewed it for the London Review of Books. It is very long, but it's very compelling. And John Reynolds, I don't know if he's here, is a fantastic, more recent book, which looks into this. And I borrowed that from them in what follows for this bit. We've got the problem of the Council of Europe's European Convention on Human Rights. And the problem we have is what to do and what to say about the colonies. So we have a number of countries that are inclined to agree binding treaties about human rights that need not to have them from the point of view of the way they treat people. And you got this fabulous quote from the representative on drafting, recovered by John. We want to keep it aspirational. So that's fine. So just let's all be lovely. But if my goodness, the pesky foreigners want more than that, then let's go with this thing called derogations as a means of strengthening the resistance in all our countries against insidious attempts to undermine our democratic way of life from within or without. It's a quote that stands examination. So it's both the external, i.e., I would think mainly the anti-colonial agitator, or the internal, who is the enemy within, the communist who wants to destroy. So we can't have a human rights idea that is embedded sufficiently to expose us to critique. And so they got, because colonial power, just like with the guy in the Court of Arbitration, colonial power had the influence, continued to have the influence for many years. We got the colonial clause, you'll know it, Article 56 of the Convention. Any state may, at the time of its ratification or at any time thereafter, declare by notification addressed to the Secretary General that the present Convention shall, subject to paragraph 4 of this article, extend to all or any of the territories for whose international relations it is responsible. So they didn't have to, they could choose to. So basically, the home and home away distinction in my book on terrorism that doesn't refer to this is beautifully emblemized in this. So we have home, where this will apply automatically, and then we have home away, where I don't know what we'll do, we might not. And I put down here, of course, famously Portugal, a retainer of colonial territories until the fall of Salazar, I think, not even in the Council of Europe. So that's one solution, don't be there. The Belarus solution, or possibly the United Kingdom solution. France were in it, but they just paid no attention to it. They didn't even ratify until 1974. And it took until, I think, Mitterrand's first year that they accepted an individual application. The Belgians ratified, but it had no application to the colonies. So it's not just a British problem. It's a colonial issue in Europe. And the Danes did extend it to Greenland. The British adopted this approach set out here. They didn't extend it to some colonies. Remember, these colonies often had colonial governments, and they were very opposed. The Hong Kong government very much didn't want to have rights. And the trouble, parenthetically, is that with Mr. Patton, the great saintly Mr. Patton, who developed a huge interest in rights when posted as the last Governor General of Hong Kong, we forget that Britain strongly opposed rights in Hong Kong until it was time for the Chinese to take over. And it discovered its zeal for human rights in the last days of its control. We forget that, but others don't. And it's very hard for them to take seriously our wittering on when they know, even if we've forgotten, that when we could change, we didn't. We didn't. And so we see here, they left out the elections one, which is interesting. You know, the article, the one that caused all the kerfuffle over Hearst, but that wasn't available in the colonies where it was extended. And then, of course, and it's the last bullet point here, there was a plethora of Article 15 derogations, which was the main British approach. So we see from the start what Mr. Johnson would have called a cake and eat it. So we wanted to be able to parade our early engagement in the Council of Europe, coming into force in 1953 with Britain up there, but in a way that didn't affect us. And the derogation became part of, looking back over my introductory remarks about my book, became part of the camouflage, which permitted people to persuade themselves that human rights were protected even in the colonial world because we had subscribed. But the small print suggests the subscription mattered very little. Legitimization was the explicit goal. I put it rather strongly, camouflaging imperial abuse with the cloak of law and human rights. I mean, for discussion. So in this report card, the Council of Europe and Imperialism, its flagship convention, was not disruptive of the colonial order and could not be disruptive of the colonial order and played very little part in producing an end to the colonial order. But the colonial order was manifestly an incredible disruption of the human rights idea, but it didn't fit. So what about the court? We had a very interesting discussion on interstate by a colleague from Ukraine, actually, this morning. And here are the interstate applications with which we'll be familiar. There's very few, as you know, and a really fascinating one, which is given enormous, riveting treatment by Brian Simpson, actually, is Greece with the United Kingdom. And there's two applications. The thing is investigated, there's subcommittees, there's this, that, and the other, and the levels of abuse arising out of the effort to end the revolt in Cyprus is immense. Parenthetically, just because I've suddenly remembered it, the language of terrorism is used extensively in Parliament to explain the need for the attacks on those who sought freedom from Britain, extensively in the 1950s, as long ago as that. But the applications may or may not have stimulated some discussion. There was agreement. There were things went on behind the scenes, and a real life figure. But it looks nowadays, doesn't it, like a sort of made up name, emblematic of British imperial grandeur. But Sir Humphrey Waldeck, whom people will remember and was a distinguished figure in this field, managed to achieve a termination of those proceedings, managed to achieve it. So it never got to the court. And so it's sort of a bit lost. Hundreds and hundreds of pages detailing abuse and so on. And there were two applications. Ireland v. United Kingdom, which I do remember, long before Conor was born, but I was alive. You'll never let me forget that one, Conor, will you? Conor Jr. Conor Jr. The tie adds years, but not enough years, man. This is regarded, actually, it's a remarkable thing. You all know it. I mean, it's amazing. And that the Irish took the British over sensory deprivation techniques to the European Court of Human Rights. Nobody thought we could ever have that level of breakdown between Britain and Ireland until Brexit, of course, where we now have it. But there were two disappointments from the courts, from our perspective, from the perspective of our human rights perspective. One was in Ireland v. UK, number one, the European Commission, which was then the body that made the preliminary ruling, found there to have been torture, breaches of Article 3. It was devastating, reported as such in 1976. The European Court of Human Rights in 1978 reduced that to inhuman and degrading treatment. Oh, so what, you might say? Well, it allowed the British, I have read the newspaper coverage of that report, I've seen the debates in Parliament, it allowed the British to present, such as the injustice of the passing moment of politics, it allowed the British to present the case as a kind of victory, so that they had been, as it were, in inverted commas, exonerated by the decision that all they'd engaged in was mere inhuman and degrading treatment, and who wouldn't, given the pressures we were under, et cetera, et cetera. So that was a disappointment. It's fascinating theme from the morning sessions I was at is to consider the political backstory to judicial decisions in Strasbourg, because we have among us all here an acknowledgement that the normative inevitability of interpretations is not present. We might pretend to others it is, but it's not. And we have another example of that with the Ireland v. England UK number 2 case, reflective of a pivotal, of a dramatic collapse in British-Irish relations after the way the British took decisions on Brexit without acknowledging Ireland. I'm sure it's related to that. And here, the court, in the teeth of an objection, a very strong dissent by the Irish judge, who is now president of the court, said, there's nothing to see here, we're not going back to it. We're not going back to it, even though it's obvious, and it was, even though it's obvious that the long-term effects of the behavior can now be seen to be, and should have been understood as at the time, and were not merely because of the way in which the procedure was addressed, can be seen as having such appalling effects that it wasn't just roughing people up, it was destroying them. It's an important point. And secondly, I exaggerate, but not by much, that the minutes of various government meetings, including senior cabinet figures, had inscribed on the sort of margins, let's go for a bit of torture, whoops, better not mention it. I mean, I'm exaggerating slightly, but the idea was that there was new evidence, as it were. And the European Court of Human Rights, over the dissent from the president now, the then Irish member said, no, nothing there. So it didn't bite on either occasion. And Cyprus v. Turkey is slightly different. And what's interesting there, we have a concentration not on the act of military engagement, but on what happens after. So we're able to deal with that individualized human rights abuses. Of course, Ukraine and Georgia are now different. Here we have 2 member states. Now, why am I including that? I'm calling it, because we haven't got time to think about definitions, but I'm calling it, for the sake of argument, attempted colonialism. So if Russia pulled it off, we would have all the signs and symbols of a colonial relationship. We'd have extraction of profit from the land, from the people. We'd have forced. It'd be a particularly brutal colonial situation, and of course, unlike, I say risking it, I may be wrong, unlike the Turkey 1974, it's instantly attacked by the Council of Europe. Good on the Council of Europe, in my partisan opinion. We've got this register of damage caused by the aggression. I've put them all down there. It's on the PowerPoint. International compensation. We've got the expulsion of Russia from the Council of Europe. I learned this morning about the number of damages cases that have been brought out of the Georgia episode, and how none of it's been paid up, and you know wouldn't have been paid up if they were members, and they're not members. And here we have Russia's aggression is in flagrant contradiction with the common ideals and principles of member states of the Council of Europe, and in violation of international law. And then we have this, the resilience, recover and reconstruction, a record budget. The Europeans are very proud of their engagement on the Ukraine matter. And there are these cases. You may know that these cases are coming. So I think there it's looking good, but it's pushing at a hugely open door. It's not hard to adopt an aggressive anti-Russian position in Europe. Now, I'm delighted it's not hard. I'm delighted there's little ambiguity. but it's not hard. Brave was this, what you might call, I mean, again, you know, we can talk about discussions, but the other was attempted colonialism, may or may not work. And this is contemporary colonialism. Now, well, the British went into Iraq, the British went into Afghanistan, they had the Americans, or whatever it is called, multinational task force of the brave, or whatever they called it, Operation Enduring Freedom. I don't know what the relevant euphemism was at the time, I've forgotten, but human rights went after them. And we have this famous quote from Bonello, and I think it's what they thought. And basically, you know this quote, I used to give it to the students a lot. I think paragraph 38 is fantastic. I would have respected better these virginal blushes of some statement had they worn them the other way around. And what it is basically is you cannot go into Iraq and then accuse us of human rights imperialism. You can't have your cake and eat it. And for my part, I believe that those who export war ought to see the parallel export of guarantees against the atrocities of war. And then, if necessary, bear with some fortitude the opprobrium of being labeled human rights imperialism. I, for one, advertise my diversity at my age. You know, he's on his way out. It is a he, isn't it? Bonello was the man, isn't it? Yeah. It may no longer be elegant to have dreams, but it's great, isn't it? I love concurring opinions. I mean, there's real personality in it. But that of being branded in perpetuity a human rights imperialist sounds to me, I acknowledge, particularly seductive. I don't know if he's still alive. I hope so, because is he still alive? I must be about 147. Maybe he's in the room. Because Lord Sumption has just written an article in The Spectator saying how Alscieni is an example of human rights imperialism. Lord Sumption has what you might call a continuous, very sharp, but repetitive focus on how awful the European Court of Human Rights is. And he has, if I may say so, deviating slightly, he had a long go at me. So I suppose I'm trying to get my own back. But he really needs to be very careful, because he says that the Britain's amazing and its protection of human rights is unbelievably brilliant. And of course, it would be a disaster if the court's jurisdiction were removed and nothing was put in its place. But I have this wonderful idea called a Bill of Rights, which will be in its place and the greatness of Britain will continue. And it is, to put it mildly, I think the relevant adversarial, polite way of putting it is somewhat naive. But the headlines are Sumption attacks the European Court of Human Rights. So they're still at it. They hate Alscieni. They hate the jurisdictional reach. They hate the idea that you can kill Johnny Foreigner and you can be caught. They hate that. They can live with the idea that you can kill somebody at home and be caught, but they can't stand the idea that you can go into another country and kill a whole bunch of people and nobody cares, because they're used to not caring. More to their taste was this. Philippe, my friend and former colleague at Matrix, has written a book on this. I haven't read it, but I imagine it's riveting because he's so a good writer. And the Chagos Islanders lost out their endless litigation because they'd taken a few quid from Britain, and therefore it'll behove them to come looking for more from us. That is contemporary colonialism. I mean, that's a shocking story, and it's in our lifetimes. What Reynolds calls an imperial mindset. I think that's exactly what it is in Britain, to be honest with you, an imperial mindset. I think it's on display with 10 minutes. Have I got as many as I can't string it out for another 10? We'll have time for question, Conor. Don't scare me. Yeah, 10 minutes only in total coming up. And 10 minutes. I have to deviate into jokes. The draft Bill of Rights, I think, was that. The Legacy and Reconciliation Act, honestly, I cannot believe that one. That is the most extraordinary piece of law. It's condemned by everybody in Northern Ireland. If they go back into power sharing, it'll be because they bond over how they hate a law imposed on them. Maybe it's that playing that very subtle game. And the Committee of Ministers in the Council of Europe, which is my report card goal, have issued very critical comments. And the Commissioner of Human Rights, very interesting critique. So they're doing well on that. I wish they did more on historic slavery. I don't know if you've seen it, but recently the United Nations has done some on that. It'd be quite good for the Council of Europe to engage in that. It'd be quite good for them to think hard about it. to be a little bit of a trailblazer. And the final thing I'm going to say is a bit, look, I'm going to preface this by saying, let's examine where we can change things now and not perpetually apologize for things we didn't do. Let's see what can be done now. So let me tell you about this. You've got, is it the case of Israel? Well, it's getting very close to being really uncontroversially something resembling South African apartheid. I didn't say it is, I said it's getting very close to being seen as that. There's a huge amount of opinion in Israel that now accepts that. It is, however, something about which the Israelis are unbelievably sensitive, unbelievably sensitive. And the new government in Israel is utterly and completely shocking, and one opposed by huge numbers of people within Israel, huge numbers. Now, I was quite surprised at this. They have observer status since 1957 at the Parliamentary Assembly. They send a 3-member delegation. They participate in various ad hoc committees and steering committees as observers. They're in the European Social Cohesion Platform, and they're members of the European Commission for Democracy Through Law. They're members of the Convention Committee on Cybercrime, and they are observers in the European Commission for the Efficiency of Justice. How could this be, you think? Well, let's check what the criteria for being an observer is. A state may be granted observer status if it is willing to accept the principles of democracy, the rule of law, and the enjoyment of all persons within its jurisdiction of human rights. All persons within its jurisdiction. What's its jurisdiction? And willing to cooperate with the Council of Europe and shares Council of Europe values. So we must deduce that the Council of Europe's view is that Israel continues to meet all those standards. Now, I have a positive proposal. Why not join the European Convention on Human Rights? Why not offer to Israel the chance to confirm its commitment to the values that it claims by allowing its citizens and residents to take cases to the European Court of Human Rights? You might say that's out of the question. And it's trivial, but true to say that they're in the European football and they win the European Song Contest. And why can't they take a step further than observer status? Or you might say, wait a second, they're not European. Well, the Statute of the Council of Europe could surely be amended. It's a very big deal. Surely Israel would join in support of that. And as you may know, you could work on this quite separately from the statute. The protocol number 14 of the European Convention on Human Rights includes an amendment to allow the European Union, not so far as I know, a country. It's got the word European in its title, but not a country. And the Israelis have already signed up to the Human Trafficking Convention. So they're in certain ones. And the ones they're in, that one says you're allowed join, you know, if you're not European, even if that's added to the convention, and it seems to be allowed. So we could have a new protocol, and the new protocol would allow those countries that are observer status to join the European Convention on Human Rights. And then we would go to Israel and say, is a wonderful opportunity for you to confirm your commitment to the values which you speak of so movingly, and on the basis of which you've been given observer status at the Council of Europe's Parliamentary Assembly. There you are, something today rather than something about the past. Done.
What solutions do you see to this issue? In our current times, when, as you talk about the UK, when countries are actively taking steps to further erode human rights and protections. Thank you.
Thank you very much. The European Court of Human Rights, when it got going, was there to preserve certain explicit human rights. And there's going to be a problem when you were in a progressive political climate, as we have been until quite recently, and still are to some extent, which is that the basic things you were introduced to protect us from no longer need careful, vigilant protection because they're there anyway. So democracy in place, rule of law in place. And so this is my take on what you've asked me about. The the living instrument becomes a means of maintaining relevance for the court. Because if it had restrained itself to what was understood in 1953, it would have very little to say about the present. And therefore, it wouldn't have many cases. And then it would be, in some ways, kind of besides the point. So the living instrument gave them the capacity to reach novel, interesting, innovative decisions on an emerging understanding of human rights, rather than on the crisp original intent, so beloved of the critics of Strasbourg. The trouble, of course, was that doing so appeared to counter the democracies which they were, as it were, established to preserve. So you have these tricks to try and avoid blowback, consensus, margin appreciation. So they're trying to avoid the backlash that you've implied, and you're right to say perhaps happens, by masking their growth, a growth essential to their own existence institutionally in a sort of cover of consensus and a cover of state acceptance. It hasn't entirely worked, and it's not entirely their fault. There is now, across a number of countries, a growing rejection of the jurisdiction of the court rather than individual decisions within it, which we're all familiar. The United Kingdom has shamefully been in the lead in that, to their disgrace, I think. But Russia, obviously, we know before they were expelled. Denmark, of all places, very critical. And as we know, the case law on Article 8 has engendered quite a lot of opposition in other countries. Now, the reason for that is not implausible. It appears to undermine democratic opinion in some countries where the living instrument and the consensus push countries to change in a way that the country itself would not choose to change if it was free to decide. We may deplore the fact they wouldn't change, but they wouldn't. So corporal punishment is an example. The same-sex developments in marriage, not quite marriage, is another. And in those cases, there's a gamble that opinion will come around in those countries. And it's largely worked. My own country, Ireland, it blazed a trail on homosexual law reform, which thereafter was made easier by Strasbourg. So that's a gamble. Well, what's begun to happen is a rejection of the underlying assumption which we assumed was there forever. The underlying assumption which we thought we'd never need to protect, which is that the individual dignity is a central element of our society, and it applies to anybody. Now, this is something which people are now believing less. We may sort of explore why. Certainly, migration is a driver, climate change is a driver, but we are now getting more used to the idea that some lives are not worth as much as others. And that's then meaning that the European Court of Human Rights, with its old-fashioned commitment to a life, regardless of where it comes from, looks like out of kilter. And so you have the current argument here led by the Home Secretary about how the European Court of Human Rights should not rule that you can't just throw people out of the country and that we leave if it rules it. That's only possible, and it's not just Britain, against a background of a view being held by more people that lives are of different value. And I think that's a huge enemy of our subject. And partly, it's very important. I think it's not part. This talk is a bit about that, about calling it if it happens, and not trying to pretend we still have human rights if we're killing people within the jurisdiction. I think, for example, just a last point here, Conor. It'd be more honest. I've raised this with people who are in favor of Braverman. It'd be more honest to shoot asylum seekers than it is to do what they do at the moment. And it's not just Britain. It's the boats nudging out of Greek into Italian waters. It's the turning the other side of your face when groups go down and sink. The government here expressed, I think, concern for the relatives of people who drowned crossing the channel. That is ludicrous. And it would be more honest if they said they're not worth saving, they're not us, but we can't do that. So we're trying to create an atmosphere of the maintenance of human rights in a world of increased possible barbarism. So we end up with the European Court of Human Rights performing its original function in a very unsympathetic climate.
Okay, with apologies to the listeners, I think we must leave it there. Conor, thank you.
Well, can we just one for a second, anonymous attendee, do we want to do it? There's one anonymous attendee. Thank you very much. I don't know if it's on the screen. You mentioned the Israeli case and bracket almost apartheid. Do you think that having Israel join the convention would help those living under apartheid, or almost apartheid? Thank you for that very well put question. I think, sorry, Conor, I'm going to answer that because they've just come in from outside. It's really interesting. You can talk human rights as values, civilizational, or you can talk about them as individual opportunities to secure remedies. It's surprising how many people talk about them as values who don't want to talk about them as remedial devices. So I'm saying, why don't we invite Israel to put procedural, substantive flesh on generalized statements? And if that were to happen, anonymous attendee, then I think it would make a difference. But of course, what I'm saying cannot be accepted because it's incompatible with the way it happens now. So it's a lever to try and draw attention to something. That's all.
No shortage of conversation starters. Share the colors.
Can we have another Conor in the picture?